The lead minister on the Canada-U.S. trade file is Dominic LeBlanc. We spoke to him just after the Supreme Court decision came out, but before the U.S. president responded. Dominic LeBlanc is the minister responsible for Canada-U.S. trade, intergovernmental affairs, and one Canadian economy. Thank you for doing this, sir. There's a lot to unpack, and we've only just got it. But what, broadly speaking, does this ruling mean for Canada?
So obviously, we were expecting the U.S. Supreme Court to decide at some point on these reciprocal tariffs. It's certainly for a few sectors of the Canadian economy is significant. I'm thinking of aerospace or some smaller businesses that couldn't be compliant with the rules of origin with the terms of CUSMA. The reality, Peter, is that the vast majority, well over 90% of Canadian exports to the United States weren't affected by these reciprocal tariffs. Those are the tariffs that the U.S. Supreme Court addressed today. What's hurting the Canadian economy are the sectoral tariffs under a different American law. So think of automobiles, steel, aluminum, softwood lumber. Those remain in place. But this just reminds us again of the importance of diversifying our trading relationships. This uncertainty means that the Prime Minister's commitment in the election to build trading relationships with reliable partners, be less dependent on the U.S. market, to build big in Canada, again, build here at home. All of those things become even more important as we head into this further uncertainty.
But the very reason the vast majority of Canadian trade went untouched by these IEEPA tariffs was because of exemptions that were provided to these IEEPA tariffs. Donald Trump has said he has a plan B. I don't know what that is. I'm sure you're not in his head to know what it might be, but I wonder what you can do today. Who can you pick up the phone and call to make sure that the exemptions Canadian firms had under those IEEPA tariffs can be maintained regardless of what the next set of tariffs might be?
And therein lies the critical question. When these reciprocal tariffs were first announced, it took a couple of days for the Americans to say we're going to exempt anything that's compliant with CUSMA, with the trilateral free trade agreement. So those are like rules of origin and so on. It's a technical process. But today, Peter, 95% of Canadian exports benefit from that exemption. So, and that's under the trilateral free trade agreement, which, as you know, is up for review this year. That's one of the things I discussed with the Mexicans this week. That's an ongoing conversation we have with the Americans. Again, I'm not a psychologist, and you're right, I don't put myself in the mind of our American colleagues and imagine what they're going to do next. We're prepared to deal with whatever they do. But if they gave that exemption to Canada and Mexico, it's because it's in the American economic interest to do that. They don't do it because they want to be nice to us. They do it because American businesses, American industries, American consumer groups told them that if you sort of unscramble the omelet that we've made with supply chains and other sectors of our economy, it's going to put inflationary pressure on prices in the United States and create economic uncertainty that'll cost American jobs. So our view always has been that the economic arguments in all three countries are what make the most sense. So we'll have to continue to advance those arguments. And we have natural allies in American industry, and certainly this week in Mexico, we can rely on the Mexicans as very reliable allies in this regard as well.
Have you called Jameson Greer or Howard Lutnick or any of your counterparts or texted them since this ruling came out?
No, because I arrived at your Radio Canada headquarters in Montreal and was overwhelmed by your colleagues trying to get me to go on the show. So I thought it would be rude to take a call with Howard Lutnick while I was live on Gérard Fillion's Radio Canada show.
Do you plan to speak to them today, though, in light of this?
Of course. I hope to speak to them later today or tomorrow. But we also want to see, again, we're focused, Peter, on the work that we are doing, what we did in Mexico this week, what the Prime Minister has done in China and other trips. We're very much focused on that work. The Americans have said that they have contingency plans for various results in the Supreme Court. We'll see ultimately what the American government does, but we remain very serene and very focused on the work we need to do.
You were set to resume talks for the first time since they broke off after the Ontario ad with Ronald Reagan. Are those talks, as far as you're concerned, still going ahead?
I think so. I have no reason to think they're not. I talked to Ambassador Greer, the trade representative, about coming to Washington in the next couple of weeks. I have no reason to think. I mean, this is the review of the trilateral CUSMA agreement. The Americans have started a process last fall to prepare for that review. So has Canada and so has Mexico. Like, this is a decision of the U.S. Supreme Court on an interpretation of an American law and the president's authority under that law. So that is a question that the American Supreme Court and American politicians will comment on. We take note that in a few sectors of the Canadian economy, it will offer some benefit, but the vast majority of the difficulty that we're having with American tariffs are not under this law. So our work remains, we need to remain focused on what we can do to diversify our trading relationships and build a strong economy here at home.
There are a lot of rulings within this ruling. There are sort of concurrent rulings and there are dissensions, but one of the things that keeps coming up is the notion that Congress is king when it comes to tariffs, that they are responsible for the ability of the American institution of government to impose these kinds of tariffs. Are you guys looking through that to see evidence of anything that might tell us that maybe the 232 tariffs could be challenged in this way as well?
Well, of course, we're reviewing, and our lawyers, both in the United States and in Ottawa, are reviewing the decision. And I expect on the weekend I'll get a preliminary document of advice on what the ruling might mean. And they'll look at all of those questions. You're right to ask that question. Again, I'm not an expert in U.S. trade law, but I do know that when President Trump in his first administration brought 232 tariffs on certain sectors, steel and aluminum, there were some court proceedings at that time. And what we were always told is that the legal basis for the sectoral tariffs, the ones that are causing us such concern now, is much different than these reciprocal tariffs. So that was the advice we were getting some months ago. Obviously, that advice will be updated with this Supreme Court, the 160-page decision of the Supreme Court today, and I look forward to seeing that hopefully on the weekend.
There are Canadian firms that operate on both sides of the border. Some of them would be entitled to refunds. Refunds aren't explicitly mentioned in the ruling. Do you think those firms should be seeking a refund of the tariffs that they paid through the IEEPA tariffs?
Well, of course, if these funds were collected by ultimately by a law that was exceeded in its jurisdiction. But that, again, Peter, these are American legal proceedings. The Canadian firms have rights under the American judicial process, but we would encourage these firms to look carefully at the decision and see if there can be refunds, of course.
I was looking through your Twitter feed when this came out. You've got, it's a fairly broad statement in terms of what you see in this and what it means for the relationship going forward. How does this, broadly speaking, frame the conversation and the state we're in? How does this ruling frame that heading into the CUSMA renegotiations?
So I think two things, Peter. As I said, it absolutely behooves us to continue the work we're doing to diversify trading relationships, to build major projects here at home. So this uncertainty and the fact that on a Friday morning we're into, again, this sort of uncertainty in the trading relationship with the United States makes it more urgent to continue that work. It's what I did in Mexico earlier this week. But I think it also tells us that we have work to do with the sectoral tariffs that the United States has imposed on Canada, which weren't covered by today's ruling. So we have a lot of work in front of us, and we'll let commentators make references to American politics and American law. We're focused on Canadian jobs and the Canadian economy and what we can do within that context, what we can control here at home.
But you maintain the position, the Canadian government, that these were unjustified and wrong to have been put in place in the first place.
Well, and you remember the original justification at the time was fentanyl arriving in the United States from Canada and migration at the border. We always maintained that that circumstance was exaggerated and didn't have merit. We've done a lot of work with the Americans at the border in the joint fight against fentanyl with the Mexicans. So that work is ongoing and is positive.
Ambassador Greer has made it clear, a bunch of people in the administration have sort of mused that they would like to see a bilateral with Mexico and a separate bilateral with Canada, as opposed to the USMCA, CUSMA, as it is today. Take aside, I'm not sure how mechanically that would work, as this is only a renewal process, as you well know. What are the dangers of going down a road where we're having two separate bilats instead of the trilateral agreement that you and the Mexicans worked so hard to establish as the priority when you're in Mexico this week?
Yeah, and I think it's important what you just said. The Mexicans are absolutely committed. We heard it from President Sheinbaum when we met with her earlier this week and her cabinet secretaries. They want to work with Canada on a trilateral agreement. We still maintain that it's in the economic interest of all three countries to pursue that. We have taken note, Peter, of the comments from Ambassador Greer and others. But I think it's important, perhaps, that we have to be precise. There have always been bilateral discussions between Mexico and the United States, or Canada and the United States, sort of adjacent to the trilateral framework, the CUSMA Free Trade Agreement. I talked to the Mexicans about some of the challenges in softwood lumber we're having with the Americans. It's not a reality for them. They're concerned about tomato exports to the United States. So there have always been bilateral conversations. We have no reason to think, and our conversations with the Americans and the Mexicans confirm the same thing. The plan is to conduct the review trilaterally of the trade agreement, and that's what we're preparing to do with the Americans.